first bill that we will hear. We're going to go slightly out of order. Is Senator Krause here?
Yep.
Okay, we'll start with this bill, Senate Bill 811. Oh, and while you're having a seat, reminder to those that are here to testify, there is a limit on the testimony to 3 minutes. Please make sure that you abide by that. Please do not read testimony. And please make sure you're testifying either for or against the bill. We do not do informational only testimony in this committee. Senator, proceed.
Mr. Chairman, members of the committee, Senator Will Crowd representing the 8th Senatorial District to present to you Senate Bill 811. This is a cell site simulator bill. In current law, it's already prohibited to intercept phone and wire communications without obtaining a warrant. Senate Bill 811 would create the same requirement for cell site simulators. Cell site simulators act like a cell tower and collect data from cell phone devices within their range. This is a follow-up from Amendment Number 9. The chairman was instrumental in passing that, which dealt with electronic data protection, which the voters in 2014 approved by 75%. Warrants would not be necessary for instances of emergency, such as kidnapping, hostage situations, terrorist activity, and other important emergencies. These devices are important to assist law enforcement. However, we must balance the rights of citizens under the 4th Amendment of the U.S. Constitution, which protects us from unreasonable search and seizure. I believe Senate Bill 811 accomplishes that goal. I'm glad to answer the question.
Okay. So I see that you're defining this in statute. It's not defined anywhere else. So this is the first time that we've legislated on this subject. Okay. An international mobile subscriber identity capture or other device that mimics a cell phone tower and sends out signals to cause communication devices in the area to transmit other to their locations, identifying information with the subscriber or customer, communication with the common carrier, or the contents of the location. Okay. All right, and Senator, has there been an incident or something that has precipitated the necessity to address this?
You know, once it came to my attention, I started moving forward. If there was a situation where warrants were not obtained in St. Louis and they actually dropped the charges on 4 defendants because there wasn't a warrant. And they didn't want to go disclose the information. It was an article in the Kansas City Star. But to be honest with you, once I heard about this, I thought, you know, what about our rights here? And I've talked to some law enforcement. I'm willing to work with them if there's anything we need to, and there is some language in here that they've asked us to work on, and we're willing to do that. We want to make sure that they have the proper tools, but like I said, we want to protect from our individual personal liberties.
So you wouldn't restrict it, I'm asking, you wouldn't restrict it as long as they had a warrant, is that right?
Correct, that's what we're doing. We're going to stick right into the wiretap area.
Okay. All right, are there other questions for the bill sponsor? Senator Under.
Senator, are these devices used exclusively by law enforcement, or are they sometimes used by, you know, say hackers to intercept personal data?
I think they're primarily used by law enforcement now, but that doesn't mean that they wouldn't be used later for other individuals.
Okay, thank you.
Other questions? You have someone here to testify?
I don't have anybody to say that.
Is there anyone that would like to testify in favor of Senate Bill 811? Sarah?
Good afternoon, Senator Sarah Rossi with the ACLU of Missouri. Just wanted to go on record and support agree with Senator Krause. That's an important measure to protect the privacy and liberty of Missourians. We take the same approach to things like this that we do to things like drones. If they're going to be used, they should be used with a warrant, and we should get out ahead of it before they start. The use of them is disseminated into private citizens and folks who would monitor for nefarious purposes. So we're in full support. Thank you.
Any questions for Ms. Rossi? Thank you. Anyone else to testify in support?
Trying to fall down, give you a chair.
It's a little tighter space in this room.
Greg White, Polk County Sheriff, and I wasn't prepared when I walked in because I didn't know it was being heard, but I do support this. And the issue is that law enforcement always has to be kept on a relatively short chain. Having been a cop for pushing 34 years, it's incumbent upon the legislature first and the court second to assure that it's not burdensome to apply for warrants. That gives the court the judgment of whether or not it should be issued. Fully support it. The warrant position on it is the correct position to take. And as of right now, it's an expensive proposition anyway, and usually we're using federal assets if we wanted to do that. But it will, like everything else, become cheaper.
Senator Under.
One question I would have, and maybe this is as much for the bill sponsor as it is for you, Sheriff. Part of our protection against illegal gathering of evidence in our system is the exclusionary rule, which the Supreme Court has articulated. But your bill also makes it a felony to do this. Is the criminal penalty necessary, or I'm just wondering about that.
I'm always willing to
Yeah,
work with lawyers and law enforcement to do the right thing. This is the way we crafted the bill. And
Sure.
if you think we need to take that penalty out, there's already penalties out there, then that's something I would love to talk to you about.
Do you know whether other states have done this? It looks like you're on the cutting edge of this, but yeah.
Georgia and Texas?
Georgia and Texas. Okay.
New York and Texas, sorry.
Okay.
I'm getting the expert in the back telling me that.
Well, my chief of staff makes me look good too, so I appreciate that, Senator. Thank you.
If I may add,
Yes.
I tend to agree with you that maybe we don't need that penalty because the penalty already exists because this classifies it in essence as a civil rights violation. ACL, you would agree with that?
Yep.
I think, and I think there's both civil and criminal penalties that follow that, so that would cause this sufficient in and of itself.
Okay. You like a 1983 action or
Yes.
something like that? Okay. All right. Thank you.
Thank you, Senator, for pointing that out.
And we're on the lookout for new crimes in this committee. Senator Everett.
Sheriff,
Question.
just a quick question. Are you testifying on your own behalf or representing anyone?
In this case, I'm testifying on my own behalf in my office.
Okay, thank you.
The criminal portion probably will have to come out. There, just as an observation, some will remember this, but when we did the criminal code revision, it came to our attention that law enforcement was actually running out of the charge codes. So we are trying to be, pardon the pun, but judicious with the assessment of the new penalties. Any other questions? Anyone else to testify in support? Anyone else to testify in support? Last call. Anyone to testify in opposition? I'd have to close the hearing on September 11th. We're now going to skip ahead on behalf of one of the witnesses who needs to leave, and I'm going to turn the microphone over to the vice chair. We're going to move to 7:34.
Our next hearing will be on Senate Bill 734. Senator Dixon, proceed when you're ready.
Thank you, Chairman and committee members. Bob Dixon, District 30, presenting Senate Bill 734. This bill is identical to its provision in House Bill 218 in the substitute we did over here last year, which was passed out of committee and at the end of the session last year was a victim of the meltdown. The bill allows sheriffs and deputies to offer law enforcement assistance in other counties throughout the state. Currently, sheriffs and their deputies may offer aid to adjoining counties upon the request of that county sheriff. This bill expands that ability to offer aid in an adjoining county to the ability to offer aid in any county that requests assistance in the state. And it also has some clarifying language that specifies that any sheriff or deputy rendering assistance in another county will be deemed an employee of the responding county sheriff's office for the purposes of believe it had to do with the insurance. I can be corrected on that, of course, during that time period only. So, be happy to answer any questions. This is a common sense thing that kind of came out of our experiences with the Joplin tornado.
Any questions for the bill sponsor? And I think it's an employee of the sheriff's office and she'll be subject to workers' comp.
That's what it was the work comp insurance. Right.
Further questions of the bill sponsor? Seeing none, any witnesses testifying in favor of Senate Bill 734? Sheriff, welcome back.
Thanks for moving us that one as well. A couple things on it. My history with this dates back actually to
So please go ahead and state your name again.
Greg White, Cole County Sheriff. I'm representing both my own office and Missouri Sheriff's Association. My personal relation with this dates back to when Pettis County had a tornado go through. I had a friend that was sheriff of Polk County, Florida. They had a situation where they had 3 hurricanes go through in 1 year, developed their own response. And in fact, they sent semis with their deputies to Mississippi after Katrina. But in the meantime, with us in this, it was just a more complicated issue. But we were able to send deputies to Pettis County and relieve their deputies for 24 hours so they could take care of their own personal business with the damage that had been accrued by their own families. And we were able to do that, but it took some quick work by our attorneys getting mutual aid agreements. What this does is it allows us to do what fire departments have done. And it's one of the things that we've learned, and I hate to tell you that law enforcement learns from fire, but we do. And there's been several things, but this critical one, and we're still working on it, is backfilling. If there's a major fire in Jeff City, surrounding fire departments are already backfilling to cover any other need that would arise in this jurisdiction. Well, in this case, we don't do that so well with law enforcement, and it begins to allow us the opportunity to continue to provide for protection of our citizens at a greater level, whilst remaining under the authority of the elected sheriff of the area.
Thank you, Sheriff White. Any questions of this witness? Seeing none. Further testimony in favor of Senate Bill 734? Going once, going twice. Any testimony in opposition to Senate Bill 734? Any final remarks, Senator? This will conclude the hearing on Senate Bill 734. The next hearing will be on Senate Bill 689 by Senator Romine. Senator Romine.
Thank you, Mr. Chairman, members of the committee. Senator Gary Romine here representing the 3rd Senatorial District, here to present to you Senate Bill 689. This is the contraband bill that we heard last year. It's frustrating that we have to itemize and detail infractions, but we do need to put into statute that inmates cannot have cell phones on the premises. So that's what this bill is all about. We want to get it heard so that hopefully we can roll it into the criminal code bill, along with a few other items. If there's any questions, I'd be happy to answer.
Any questions for the sponsor? Is there anyone here to testify in support?
Chairman, Senators, Jeff Parole, I have this Department of Corrections. Just want to go on record as support this bill. This is a priority for the department, an issue that we've come to see as a problem. We hope that this legislation could help solve that, and happy to take any questions.
Sir, Jeff, what are you doing right now? Are prisoners really allowed to have cell phones?
They're not allowed to have them. Currently, it is a misdemeanor offense, and so when we find an inmate with either a cell phone or a cell phone component charger, that sort of thing, it is a violation which is written up, sent to the prosecutor. Since it is a misdemeanor, we have found that it's less likely that a prosecution will go forward with charges. By making this a felony, we are hoping that it would entice the prosecutors to seek the charges and move forward that way.
So this bill's a change of that.
Yes, this is something that not only is seen within the state, but around the country has become somewhat of an issue in all correction facilities.
And are they smuggled in generally in gift packages from the
Yeah,
outside?
most of what we have found, they are smuggled in through packages like that, word release programs, visitors, and that sort of thing. And this also covers people who are trying to smuggle them in as well. They would also face the felony charge.
Thank you.
Question for you. Can you describe, I mean, so everyone has kind of got the picture here, what the scenarios are? Obviously, they can use them for communicating with folks on the outside of the prison.
Right.
What kind of things are going on? What are they using them for?
They can,
essentially, why do you have the policy?
well, they can continue to communicate with the outside, which is against policy. They also can use them to order hits on citizens on the outside. They can order hits and on institutional folks. They can order hits on other inmates and other institutions. They can continue running their illegal activities on the outside. We just, any kind of outside communication like that outside the wire is a safety issue.
But you all provide phones for them to use. You provide a
Correct.
telephone for them to use at the yes. Any other questions for the witness? Thank you very much. Anyone else to testify in support? Senate Bill 689. Anyone else in support? Anyone in opposition?
Hello again, Senator Sarah Rossi with the ACLU of Missouri. Our opposition is very narrow. Having a cell phone in prison is already penalized within our criminal code. I don't think the higher penalty is going to prevent the cell phones actually getting in. And I'm worried because I know that there are probably some people who are using cell phones for nefarious purposes, but there are probably some people using cell phones because they can't afford the exorbitant prices that the prison system charges them to call their family members and call their attorneys. Every conversation they have on the prison provided phones is recorded. That includes conversations with their attorneys or their public defenders. So probably a lot of that temptation to have that cell phone comes from the fact that communication otherwise is very difficult. So I would just recommend, instead of hiding the penalty for having a phone, making communication with their attorneys in the outside world a little bit easier for the prisoners, and probably decrease the instance of having cell phones in prison. That's my only opposition.
Okay. What is that cost?
I can't remember the exact number, but I'll get it to you.
What's the cost for them to use the phone?
Either 7 or 13 cents is what's sticking out of my mind. It's one of the cheapest in the country. I do know that.
7 or 13 cents for a prisoner is much more than it is to us.
I don't know if I call it exorbitant, but
Do you know how much? I mean, I'm not sure how much they earn within prison, but it can't be a lot. It can't,
No, I'm
can't
aware of
necessitate a
that,
lot of
but-
communication.
I just want to make sure we get all the facts on the table.
For sure.
Any questions, any other questions for the witness? Senator Ross.
It would seem to me the cost of the cell phone service would be a lot higher than the 7 or 13 cents.
And I'm not sure, how they pay for the cell phones or anything like that. I'm saying that the communication would be easier for prisoners and probably decrease the instance of cell phones in prison.
Yeah, thank you.
Thank you very much. Anyone else to testify in opposition? Anyone else in opposition? Okay, seeing none, that will close the hearing.
Thank you, Mr.
Senate
Chairman.
Bill 689. Senator, thank you. I know since this is our usual time slot, we've got folks that are in other committees, so. Okay. We'll now move to Senate Bill 604, Senator Pearls. And Senator, thank you for your patience over there. I apologize, I had to go out of order. So, you are always so accommodating. I appreciate it greatly.
Good morning, Mr. Chairman. For the record, I am Senator Kiki Girls of the 9th District in Kansas City, and thank you for allowing me to present Senate Bill 604. Mr. Chairman, Senate Bill 604 requires the Department of Corrections to enhance educational programs offered by the department to increase the number of offenders who earn GEDs, to provide job and life skills training, to work with schools and employers to offer training programs that will provide occupational certification and licensure. It also provides that the offenders, upon completion of those programs, receive a copy of the certification or license upon their transition from incarceration. Mr. Chairman, I think all of us know we want offenders to become productive members of society with little recidivism. The key to that, Mr. Chair, is education. We know employment and sobriety. The Department of Corrections, over the last couple of years, for various reasons, of course, have scaled back their educational programs for offenders that happen to be housed here. And it's our hope this bill helps to address that. It's a pretty simple bill. And with that, I'd be happy to answer any questions.
Any questions for the bill sponsor? Are there those here that would like to testify in support? Senate Bill 604.
Hello, Rachel Greathouse, and I'm with Empower Missouri, and we just wanted to go on record to support this bill. I think it's a great one, and that offenders should be able to get their GED. So thank you.
Any questions for Rachel? Senator Emery.
Maybe this is for Senator Kroll, but on the fiscal note, it says it could exceed fiscal note. Do you know what? I'm just now looking at it. I apologize, Senator. I haven't read the supporting comments, but do you know what is being looked at there in terms of the could exceed?
Well, I think it could exceed, and I think it's actually a positive fiscal note, as I see. Just in hoping that, folks upon their release, of course, are more prepared to enter the workforce, and that they're able to obtain licensure or certification from OSHA or other licensure, of course, that would help them in their job searches and help them with employment. And we know that employment and education, and as I said, sobriety earlier, certainly contributes to the decreased recidivism.
Sure. Well, and I understand that. I'm assuming this is some estimate of what it would cost to introduce the training programs, and maybe they could exceed me just because I don't know how many will qualify for them or something.
Well, I think if I'm not mistaken, it's a positive fiscal note. It's a positive fiscal note. Yes, it could exceed $364,000. I'm certain because of the additional employment that would be able to be obtained by offenders when they're released.
Yeah, I think this looks like they're adding 6 FTEs.
They're accounting for their costs, but they're not included. What's not included, it appears to me, Senator, apologize for interrupting, but
No, please do.
they're not including the positive side of what she just mentioned, which is probably can't be quantified down the road. But
Oh, I'm looking at last year's fiscal
Yeah, this is a negative, but
I'm
it's,
looking at last year's.
I'm sure the chairman is right that it's very difficult to account. If there is a decrease in recidivism, then obviously there's going to be a decrease of costs.
we know it's going to be positive. We don't know how much.
Right.
Okay. So this looks like this is primarily for the equipment and the additional people that they're going to need to supply.
And I will say that over the past, I think a few years ago, they had a substantial cut to their educational budget. And this is really to encourage the department first to try to figure it out, actually. I mean, of course, it'll be subject to appropriations, but we need to get back to at least the mindset of knowing that we need to be educating folks and providing them with life skills training before they release the course.
Thank you, Senator. Thank you.
Senator, it's been a pleasure to work with you on the expungement bill.
It is.
And
Thank you.
this kind of ties in with that in a different sort of way. But you mentioned the reduction in some of the programs from years back.
Right, it was 2011 or 12.
When I was out at, I should be careful how I say this. I started to say when I was out at Algoa. When I went out to tour, it's been a number of years ago, I know there were a lot of nonprofit programs that were being operated by organizations. I went out with a nun who was showing me a program. With those reductions, are those programs still?
Right. And
Are they basically the primary ones now?
I believe, well, somewhat. They still have some FTE, of course, that provide the GED training. But, you know, the legislation also encourages them to bridge other partnerships with other nonprofits and other organizations that might be able to give some assistance to the department as well.
Okay. Thank you. Anyone else to testify in support?
Rita Lenhart with Missouri Catholic Conference, and we just want to go on record in support of this bill and to thank the senator for sponsoring it and the committee for hearing it. And just like anything else, job training and education are the key to success. And so we think too that this is a good step towards saving the state money in the long run.
Any questions for Rita? Thank you. Anybody else in support?
Good afternoon, Michael, Director of State Public Defender System. I'm compelled to testify in support of this bill because at the Public Defender System, one way to reduce our caseload is to have fewer clients. 99% of inmates have one thing in common: they're getting out. They're going to get out at some point. So the question becomes, what kind of inmate do you want released? An educated one or uneducated one? You know, the studies have been done that the number one factor affecting recidivism is employment. So that everything we can do to get these guys jobs will pay dividends in terms of, you know, reducing the number of victims long term and reducing the number of tax dollars that have to go to corrections. So, thank you.
Thank you. Any questions? Very much. Anyone else to testify in support? Last call. Anyone to testify in opposition? I'll close the hearing on Senate Bill 604. We'll now proceed to your Bill 674, Senator.
Thank you, Mr. Chair. Again, for the record, I'm Senator Kiki Curls of the 9th District in Kansas City, and thank you for allowing me to also present Senate Bill 674. Mr. Chairman, Senate Bill 674 authorizes the Board of Probation and Parole to review the case history and prison record of any offender that's incarcerated that had no prior felonies at the time of their conviction, who has served at least 15 years and received a sentence of 15 years or more. The board would review those cases and look at the circumstances, Mr. Chair. They would look at their role in the crime, the severity of the sentence compared to their role, and whether a plea bargain was offered. They would look at their time served, their behavior during time served, and look at whether they appeared rehabilitated while still serving time. At that point, Mr. Chairman, the board would make recommendations depending on the circumstances as to whether the person should remain incarcerated or whether they should be considered for clemency. It also adds that should the board find that the offender's age and maturity level influenced their judgment at the time of the offense, or if the offender was found to be physically, mentally, or sexually abused, then the offender should be eligible for parole review. It doesn't mean that they would be granted parole or released, but at least eligible for a periodic review, and just allows them to be considered, especially if they've served at least 15 years, exhibited model behavior, are considered rehabilitated, and are not or no longer a threat to society. Again, Mr. Chairman, this would only apply to those incarcerated persons who this happened to be their first felony offense. Mr. Chairman, I know this tends to be something a bit controversial for some, but we need to begin to have the discussion. And we need to begin to have the discussion on those folks that are incarcerated, that may have committed a crime, of course, when they were very young, that happen to be serving very long sentences. Maybe they had taken a plea deal, and are happen to be incarcerated for an exorbitant amount of time compared to the crime that was committed. So, you know, it's time that we begin to have the discussion, and, you know, I was hoping that we could at least begin here. Thank you.
One question I have for you, and I see on second page, the criteria that's listed out there in our, no, I see, it is not limited to. So all of those things, at least those things, anything else. Okay. Answer my own question.
That's okay. You know, sorry.
It's okay. Any questions for the sponsor? You have witnesses you'd like to call?
Not certain.
Okay. Anyone here to testify in support? Please come on up.
Good morning. I'm not really told with the, I work for the public defender's office, but I'm here on behalf of National and Juvenile. Sorry, is that better? Thank you. My name is Natalie Hull, that's spelled Hull. I am a public defender, but I'm here for MACL and the Juvenile Justice Committee, and we are in support of this bill, mainly because of the aspect of it that addresses the juvenile and adolescent development that is affecting the youngsters, if you will, that are committing crimes at 17, 18, 19, even as far as 21 years old, before their brains have finished fully developing. Because of that, we are in support of this bill, allowing them to show that they have grown up, matured, learned their lesson, if you will, and are prepared to be able to be productive members of society. Thank you.
Thank you for your testimony. Any questions for this witness? Senator Unger.
Well, maybe not so much a question, but a comment. After serving on this committee, second year here, I hear over and over again this business about juveniles and their brains not being mature. And I have some teenagers, and they do things like forget their homework and don't take a shower and don't forget to do their chores. But I don't know. I think when we're talking, armed criminal action, various crimes involving homicide, armed robbery, I don't know. I don't know that I'm ready to tell they were just not grown up yet. I don't know. What say you?
Well, first of all, kids don't understand life yet. They don't understand what it means to take away someone's life. Nowadays, our juveniles are raised on what are called first-person shooter games, which are video games from a first-person viewpoint. And to them, oftentimes a gun is just another video game controller, and they don't fully understand what they're taking away from someone when they hurt someone. And I know from my work as I specialize in juvenile defense, and through my work with that, as well as the adults that I've represented, many of them have told me when I hit my mid-20s, I understood. I began to really understand what decisions I'd made before and how wrong they were. And a big part of it is with the adolescent development, they're not making the decisions. They are truly being governed by their hormones, by their inability to process, to reason, and to take into account long-term effects of their decisions. And it's one of the reasons we don't even let them vote. We don't let them get a credit card until they're 18 because we don't trust them yet. And that's part of why we're in support of this.
Thank you.
Senator Emmer.
Thank you, Mr. Chairman. Can you tell me, I don't have the bill in front of me for some reason. What types of felonies are we talking about that would be actually come under this section of law? And I'm fine, Senator, if you'd like to answer that.
Right. This would be all felonies for those where it happened to be their first time felony offense, though. Right. So it would not exclude any felonies, and it does not necessarily release anyone. It just allows us to open and review some of the cases that may have excessive sentences, depending on the circumstances at the time of the trial.
Okay, and I'm not familiar enough with sentencing to know what types of felonies would require sentences that are longer than 15 years. Can you give me an example of the sentences that would be, the crimes that would be longer than 15-year sentences?
Well, let me say this. There could be a variety of felonies. I will say most recently we had the issue of the gentleman with the marijuana offenses that was in prison for was it over 20 years? So it could potentially run the gamut. But as I said, it would be specific to those folks where this offense happened to be their first felony offense. So it would not be the repeat felons. It would not
Right.
be folks.
No, I understand that.
Okay.
I need to get more information on what types of felonies would have longer sentences than 15 years.
I think it could be a variety.
Yeah. Okay. And then regarding the witness, and I appreciated Senator Under's question. I was sitting there with kind of the same question in mind. Is that I'm not sure I understand. I mean, I have 4 children that are grown now, and I'm not sure that there was a point at which I thought, well, they really don't know right from wrong. You know, I don't know, I struggle with that. Their brains are not developed. The fact that they're still growing doesn't necessarily tell you very much about what they're, you know, a 15-year-old is still growing physically too, but he may be a great basketball player. He just gets better, or a great football player, or, you know, a great athlete, but he's still growing. And I don't know that you really understand that other than just to use it as an excuse to I guess, interrupt the normal process of law and order. And so it's something that I wish, and I understand that, you know, a psychologist or psychiatrist will tell you, well, this is what we know and this is what we know, but we didn't used to have that problem. Now, if you look around the world, I think we're the only country in the world that even has a class of people known as teenagers. Everyone else has children and adults. But we have this class of teenagers where what we do is we acknowledge that they have the bodies of adults, but we don't hold them responsible to be adults. And I'm concerned that this helps to feed that mindset, is that there's this section of the population which really doesn't have to be responsible because they can't be. And I'm not sure I understand or agree with that.
Well, first of all, this bill doesn't take away their responsibility. They've been sentenced to a minimum of 15 years in prison. So at this point, the youngest would be a certified 12-year-old who would be serving a minimum of 15 years, and he would be 27 years old when he came before this bill. Or
Would their brains be completely developed by 27 years old?
That's what the studies show, is
Okay,
that.
so they'd be out in time to be, okay.
Well, that's if he got that 15 years. But a 12-year-old, I mean, I hope we don't sentence a 12-year-old to life in prison, but it's certainly possible under our laws to do that. And were that the case, then this bill would give them a chance to take a look at him when he was 27. But in a less extreme and more common scenario, we could have a 16 or even a 17-year-old who was an adult at the time of his crime that is sentenced to 20 or 30 years in prison. And this allows, when he's 30 years old, to address who he is as he is now. With all due respect to everyone's children, they probably didn't grow up in abject poverty. Your children probably didn't grow up with the drug influences that many of the public defender clients did. And all of those things affect the development of, well, it's the prefrontal lobe, to get very technical with you, but all of that affects the development of those. And to cast this blanket across all juveniles just based on the ones that we happen to know, they're not the ones that this would affect. The difference between right and wrong and knowing that it exists and it's there, but what's key is the ability to act on that knowledge.
So does poverty make the brain grow slower?
It does affect development of the brain, yes.
Poverty
absolutely.
does?
Growing up with poverty with a different type of influence as far as education
Well, no,
goes.
I'm not talking about the influence. I'm talking about just, I mean, we've had poverty for forever, and we have young people come out of poverty with, I mean, poverty isn't necessarily, I can't see where it's detrimental necessarily to brain development. I can see if you grew up necessarily, you know, in some kind of a surroundings that can affect your brain as you're developing.
It
But
affects
poverty
diet.
itself is just a condition.
It affects diet. It affects the different things your brain is exposed to as it's developing.
Well, it can, but I mean, I've known people that didn't have much money who still fed their children.
It is one of the things that the studies are showing affects the development of the brain.
Thank you. Thank you, Mr. Chairman.
I'll just mention a couple of things with regard to the punishments and the crimes we're talking about, because this committee is considering a bill which I sponsored, which addresses the Miller versus Alabama fix, which is one of the crimes that someone could be sentenced for the time period that we're talking about, life in prison without parole for juveniles, which is currently on the books for first-degree murder. Actually, it could be more, if I'm not mistaken. The range for second degree would even be, the way it is currently, is more than, or could be more than 15 years. But we're talking about the most heinous of crimes, the kind where, not to get too graphic for those who perhaps just had lunch, but you know, I've taken a criminal justice class in my life, where the offender not only commits the crime, but then makes a painting with the victim's blood all over their kitchen cabinets. So we try to make the range of crimes fit not the age of the offender, but the crime. And then we have some variations in statute for the taking into account the variation of the age. And I appreciate Senator Emery's point. I typically try not to make it a point to opine too much in committee, but I felt with my kids, they knew right from wrong, but there was a point at which I questioned whether they'd been abducted by aliens or something, you know. And the reality is that not everybody's raised the same, and quite frankly, if all kids were trained up in the way that they should go, as Solomon said, we probably would not be having this conversation today. But there is human will, there is brain development, and we are faced with these realities today. I do appreciate what you're saying, but we have to have some, at least some options in statute for the types of crimes that are really unthinkable, regardless of age, frankly.
Just real quick, a juvenile sentenced to life without parole would not be, would this bill affect that at the 15-year point? You'd look at
It would, and let me say this, so this bill is not an attempt to relieve anyone of liability if they happen to be teenagers, okay, I want to make that very clear, that's not my point here. But, for instance, a mom I had spoken with who has been very much an advocate for this review of these cases, had a son. He came from a very good family. He had no priors, like no misdemeanors, had never been in trouble before, he was arrested. He happened to be with a bad group of boys who, bad news, okay? Someone was killed in the process. He was not actually the one that committed the murder, but he was certainly there with a group of boys who had at the time. He'd gotten, and I'm trying to remember the number of years, I wish I had called her so she could come testify because it's really compelling, but he had gotten over 20 years. He was sentenced for over 20 years in prison. And he has been a model offender since he's been within the system. And so in those cases, that's somewhat what this is trying to capture. Those, I'm not relieving any of the juveniles of any responsibility for the crime that had been committed. But just so that we can begin to have the discussion on opening and reviewing some of the cases in instances where some of the sentencing may have been excessive for the crime for their participation.
I just want one clarification.
Sure.
The gentleman who was serving life on various drug charges, that he wouldn't be affected by your bill because he was in jail for life, 3 felonies, 3 strikes, and you're out.
Oh, you're right.
Yeah.
Okay. I apologize.
But just, the poverty thing, 1 billion people in the world today, 1 billion with a B, live on $1 a day or less. They're not all sticking guns in people's faces and pulling the trigger. They're not all raping people. They're not all committing armed robbery. So, poverty in the United States, poverty in other places in the world, in sub-Saharan Africa and some parts of Asia, is just, dire. So lack of money alone doesn't cause one to do this. But nutrition, the number one nutritional problem among poor people in the United States is obesity. So, it's I don't know, eating junk food causes you to commit felonies. I don't buy it.
May I address that? Yes. This kind of goes to a question that you asked earlier about ranges of punishment. And for a B felony, the minimum that you can get is 5 years and the maximum is 15. A B felony would include if a young man, 18, 19 years old, went into someone's home, somebody happened to be sleeping, and took an Xbox. That's a burglary in the first degree because someone is in that house, and he could get 15 years in prison for that. 19 years old, going in to get an Xbox and then leaving. No one was hurt, but because someone was present, he could face up to 15 years. And this bill would take a look at his behavior 15 years later to decide if do we really need to keep. Now he would get out at that time, obviously, but I'm using that as an example. If there was a second offense or a second thing attached to that, a second count, it could be run consecutive, and so it would address that. A second count could include the stealing of the Xbox. because it's just the going in to that building that's the burglary, the taking the Xbox, and if it's a fancy one, because aren't they like $1,000 at this point, that could make that a felony, and he could be facing up to 22 years in prison based on that. So it would be a way to look at, should this young man have to serve the next 7 of that, or has he been a model offender? Has he learned things? Did he get his GED? Did he do things that could create or that could make him a productive member of society? And that's not sticking a gun in somebody's face. That's not a heinous crime. That's what used to be B&E, breaking and entering. But it is something where you can look seriously.
Thank you. And a couple of questions, I guess. Is this the part of the parole board that does all this? Does this just fall into their jurisdiction?
Yes, yes, it's outlined in the bill, would be the probation and parole board that would then do the review.
Yeah, I'm sorry, probation parole. And so they're the ones that would decide who qualifies for this, and then they're the ones that would decide whether or not.
Well, they would make a recommendation. Right.
And they make that recommendation to whom?
To the, yeah. They would make a recommendation to them, depending on the circumstances. If they so decided. I mean, the reality is, as you guys have discussed, most of these cases probably would not be recommended for clemency. But what it does is at least begin to open the discussion on some of these cases that really deserve review.
And I guess just, I don't think Xbox thieves are the ones that the committee's concerned about. I mean, I know that there's that end, but I think it's the other end of who would come into it. So I don't know if there is a way to reconsider that language so that it's somewhat narrower or not, but I don't think people are concerned about the Xbox thieves and looking at their cases again. I think it's the other end of the spectrum that is the concern. And the problem is that the way the bill is written, they both come in at the same speed.
Right, I understand that. So let me say that I'm certainly willing and open to have any discussion on this whatsoever. I mean, I get it, I do, but I do also recognize that from my district and in my community, there are a number of cases that folks, you know, we had the discussion on the floor the other day of those who feel trust in the system and those who, by way of other circumstances, feel as if the system has not served them fairly. I'll say that. So, you know, I don't mind if we need to make this more narrow. I don't mind if we need to have more discussion. The purpose really is just to really begin to have a serious discussion about some of these cases that need to be reviewed.
Thank you, Senator. Thank you, Mr. Chairman.
Thank you very much. Appreciate your testimony. Please be sure to fill the witness form out. Anyone else to testify in support?
Again, I'm Rita Linhart with Missouri Catholic Conference, and we want to go on record in support of this bill. We realize that this is just a starting discussion, but we think it's a good discussion to start to look at, to maybe try to bring some sentencing issues in balance. Nobody's going to get out of jail with this card. This is a matter of reviewing. And, you know, corrections is that title, corrections, because we believe in rehabilitation as part of corrections. So this gives them, the parole board, the opportunity to look at some of these cases, including the seriousness of the crime, and deciding, you know, maybe is this person eligible for another chance or not. So anyway, we just are glad the discussion is starting.
Rita, a question for you, because I think you probably would know the answer to this. What is the, for lack of a better term, what's the record right now, you know, off the top of your head, those that are going before the probation and parole board? How many that are reviewed are?
I think I saw once about 9,000 hearings a year. Does that sound right? I think I read that somewhere. So maybe there's somebody here that would.
We may get someone from the department to address that.
I'll get it for you.
Okay, all right, great.
Does that even sound like in the ballpark?
That's about the number of parole hearings we have a year, but I think he's asking how many are recommended.
Oh, how many are
release,
recommended for release?
How many are recommended for release out of those?
I saw once where something said 18,000 people are released a year, but that's not all through parole hearings. That could be people who completed their sentence as well. So
I just want to know kind of what the thought process is of the current makeup of that board, since we're talking about this. Okay.
Okay.
Any questions for Ms. Lippert? Thank you very much. Anyone else to testify in support? Anyone else?
Chairman, members of the committee, Jeanette Oxford from Parole, Missouri. We want to testify in support. I think there are multiple things going on related to this brain development question. One is, yes, certainly poverty within itself does not necessarily negatively affect the brain's development, but the architecture of a child's brain, about 90 to 95% of it is in place by age 3. So if in those first 3 years of your life you are exposed to constant stress, things like your parents shoving you in the floor because there are bullets flying around where you live. A couple of stories that I heard when visiting Sister Berta at Operation Breakthrough in Kansas City about a mom who lived at a bus stop with her child for a month and didn't miss a day of work. She managed to get her child to school, go to work, and then sleep at a bus stop for a month. You can imagine how frightening that might be to a 3-year-old child. And then another parent who was squatting in an abandoned house and would sleep with her children against the wall and her on the outside of them because other strangers would come in the dark and lay down by them. And this was her best chance right then to have a roof over their head, was to squat in this abandoned house and have other strangers sleeping near her and her kids at night. Children that grow up in those circumstances have brains develop a lack of impulse control. They have that flight or fright impulse out of self-preservation. And the good news is that it can be reversed in young children, just like children can learn languages before age 7 or 8, way better than we as adults can. You know, when I took Koine Greek in preparation to go to seminary, it was hard for me. You know, it's hard to speak Greek with a Southern accent like I have. So we had some disadvantages as adults. But children's minds are very flexible, very plastic, very adaptable, and children are resilient. So some of these children who had their brains developed when they were very, very young may make bad decisions because of not having developed the ability to control impulses, and because they have PTSD from the kinds of things that they've gone through. And some of those crimes may result from the way their brains have developed out of all this, just the stress of horrible circumstances in their life. And then there are some things that teenagers tend to believe around things like invincibility, that they have Superman impulses, that also may lead to some bad judgment. So there's a couple of things going on there. But the good news is that earlier in our lives, we are very able to be changed. With early interventions, people can have their lives turned totally around and can be very productive and fruitful citizens for our world. So again, this does not say you're automatically going to be released from prison. It says, let's take a look and see if there's some circumstances here that show signs that this person has changed. It would be a remarkable thing if somebody could, you know, pass themselves off as making great progress and being a model prisoner for 15 or 20 years in a row, somehow to get released when they're really up to no good. That would be pretty hard to pull off, I think. So taking a look is a good idea, and I know some of the folks on the parole board and know that they would be very careful in how they made that judgment, I believe. One of those folks I served with, a man named Kenny Jones, that I think is a remarkably honorable man.
I would agree with that as well. I appreciate your comments on brain development. I'm certainly no expert, but when I felt like one of my daughters was thinking that she knew everything, I just reminded her that I was getting to the age where I was going to become less and less intelligent, but I would recover fully by 25. Time she reached 25. Okay, any questions for this witness?
Senator, Mr. Chairman, can I ask you a question? Do you know, can you find out if there's any opposition testimony? I have a couple of questions, but they might be better if there's opposition.
Is there anyone here to testify in opposition?
Okay. I just want to make sure I didn't miss my opportunity to ask the questions. Thank you. No questions. Thank you.
All right. Thank you very much.
I'll also share a slideshow from our most recent conference. It's about toxic stress and what it does for brain development by Dr. LaDonna Pavetti, and then I can take any questions you have about that.
Okay, if you can get that to us, we'll distribute that to the committee.
Thank you.
Anyone else to testify in support? Okay, those in opposition?
afternoon. Senator Dixon, members of the committee. Matt Selby, Stone County Prosecuting Attorney. I'm also here on behalf of Missouri Association of Prosecuting Attorneys. I'll just try to address a few of the things that were brought up. I'm here in opposition, but there's really only two general circumstances where this would even come up. First of all, it has to be a 15-year sentence, so it has to be a major crime. And then for the person to be in there long enough to serve that much of the sentence, there would be basically two ways. Either that person would have to have been to prison probably 3 or 4 times, which this doesn't apply to. And the other way would be if they have committed what's defined as a dangerous felony and they have to serve 85% of their sentence. Even if we were looking at the first-degree burglary and the stealing that could get the absolute maximum sentence, which would add up and run consecutive and add up to 23 years, that person would probably get a parole hearing at 5 or 6 years. So that wouldn't apply to this. Now, going back to Senator Emery's question about what type of crimes, these are specifically designated in the statute, and it would include arson first degree, which is when someone burns a house or a building down with people in it. So it's not just going out and setting a hay bale on fire. Forcible rape, first degree rape, statutory rape when the child is under the age of 12, murder, first and second degree murder, driving while intoxicated, where the person is a habitual offender, which means they have at least 5 DWIs, or the DWI resulted in an incident that killed 2 people and that were not passengers in that particular vehicle. So those are primarily the crimes. Kidnapping, robbery first. Robbery first is another 85% crime. Robbery first would be when someone forcibly takes property from another with the use of a weapon. So as you can see, these are the worst of the worst crimes. And even then, it's still going to have to be at least a 20-year sentence, because 85%, well, probably 19 years, because 85% of that is 16 or 17 years. So it has to be a very serious crime. These crimes are specifically set out by statute, and there's going to be a very long sentence even on those crimes. The bill is not limited to juveniles. It includes any offender. And the other thing I would point out is so many of the things that are mentioned in the bill to be considered by a parole board, I would submit that those things go into, they're taken into consideration when we as prosecutors make charging decisions, when we make plea negotiations, and they're also taken into account at time of sentencing by the prosecutor, by the defense attorney, and by the judge. So those would be the primary points I would make. Be happy to try to answer any questions.
Any questions for this witness, Senator?
Thanks, Mr. Chairman. And you may have inadvertently answered this question just in your testimony, but one of the things I was wondering, I know in the name of tough on crime, we in the legislature have a tendency to mandate sentences sometimes instead of leave it to judicial discretion. Have we created some of the apparent need for something like this with the mandated sentences or the 85%? Or, I mean, is there a realm of that this is trying to back us out of some of that? I'm wondering if these are two kind of in conflict approaches to crime.
Well, I would suggest, Senator, that at the time the statute which sets out these what's considered dangerous felonies was made, what was put into that definition were the crimes that the legislature felt like people should serve long sentences because of the nature of the crimes, that these would be people that would tend to be dangerous if they got back out. And I think also, which is an important aspect of this too, is that it creates some certainty for the victims of these type of horrible crimes. Rape, murder, first degree assault, which is when someone has a serious physical injury as a result of an assault, kidnapping, I didn't already say it, rape or sodomy. And so I guess, yes, there would be conflict because these crimes were specifically set out by the legislature because of the horrific nature of them and the desire or belief that they should serve long sentences for all the sentencing objectives because they're dangerous, because of punishment aspects, and to give certainty to victims. And the proposed bill, at some edge of that would obviously cut inroads into that.
Okay, and it does seem, I think, I'm concerned that, your testimony about that there is not much discretion here in terms of who can qualify into this, and whether it's an 85-cent mandate, whether it's life without parole. It doesn't appear, and it appears that those would qualify within context of this legislation as well to be reviewed by the Parole Board. And in fact, the language in the bill says if an offender has ever been physically, mentally, emotionally, or sexually abused, or the offender's age, maturity level, or any contributing influence, etc., then they can be considered. And do you know anyone convicted of the kind of crimes that you're describing that wouldn't have some evidence of physically, mentally, or emotional abusement or sexual? I mean, this looks like it's virtually saying everybody. First offense, I think the senator has definitely qualified for this. It has to be the first offense. But it looks like everybody who's had a first offense would qualify just based on those qualifications.
I don't think those factors that you mentioned are qualifications to be considered.
This says anyone who has suffered any of that qualifies, are eligible for parole.
I may misunderstand your question, but if they are a first offense and they've served 15 years, they would be eligible basically for a parole hearing. And then the rest of that you're talking about would be factors to be considered by the board to determine whether or not they should be considered for parole. Does that make sense?
Whether they should recommend clemency.
Right. Well, the section says if the board determines after study and review of an offender's case pursuant to subsection 1 that the offender has ever been physically, mentally, emotionally, or sexually abused, or the offender's age, maturity level, and any contributing influence at the time of the offense affected the offender's judgment, then after serving at least 15 years of age, the offender shall be eligible for parole. So basically it's saying in 15 years is the limiting factor. The other thing, I'm guessing that virtually everyone in prison is going to qualify under one of those conditions, being an influence on their crime.
I can just interject here. The part that determines whether, the way it's written, the part that is determining whether they get the hearing is at the bottom of page 1, top of page 2. So those factors make it an automatic. They shall be eligible.
Right. That's what I just read. Was the bottom of page 2.
The rest of it is, it doesn't require, the rest of it down there on section 6 is the items they have to take into consideration.
But this says they're eligible for consideration. They're eligible for parole, right?
You have two things. You have the hearing and then you have clemency. All it says about those things is that and correct me if I'm wrong, Senator, those have to be taken into consideration. It doesn't say what they have to do with those considerations, but into their decision about whether to do clemency or not, to recommend clemency. But it doesn't limit it to those things, correct?
What he's saying is correct. What you're saying is correct. Although they would be eligible for a parole hearing or parole review.
Right.
Yes.
They're going to get on the list for a hearing.
Right.
That's all I'm saying. Is it?
But that sounds like parole. It just means that they would open a case and they would yes.
Right. And then they would go into the hearing, and that's when they would consider all those things that you've listed that have to be considered.
Right.
Right. No, I'm just, my question is concerning eligibility for having that hearing. And it looks to be like no one is going to be ineligible for having that hearing other than somebody who's on the second or more offense. I don't know if you know.
I agree with what you're saying, that basically anybody that gets to their 15 years is going to be able to claim this, which then makes them eligible to have the hearing.
I would agree.
Even if they were on life without parole, this would qualify. Okay, thank
For the
you.
hearing,
Thank
that's
you.
right. Any other questions for this witness?
I just want to make sure, Mr. Chairman.
Senator, go ahead.
So I'm clear on that. That does apply to somebody who's been convicted of a life sentence, so big life without the eligibility of parole.
That's what it reads.
Yeah, I mean, that's a pretty substantial change because when you, for example, when we had a big discussion on the death penalty yesterday, and I mean, I've been in a situation of pleading people out for life without parole in exchange for not going after the death penalty. And I mean, and that issue is you're assuring the victim's family that that person is never going to get out of prison. And that's usually part of the discussion that the prosecutor has with the family before those decisions are made. So for somebody to serve 15 years on life without parole and then get out, I also think there's potentially an equal protection problem on number 3. Because if you're saying if you were born into a household that had no problems growing up, you don't get this. But if you had this list of things, then you do get this. I think that's an equal protection problem. Thank you, Mr. Chairman.
Any other questions? Thank you very much. Appreciate you being here. Anyone else to testify in opposition? Okay, that'll close the hearing on Senate Bill 674, and we will now move to Senate Bill 742.
Hopefully this one will be easier. Okay, please open discussion. What else have we? Mr. Chairman, for the record, again, I'm Senator Kiki Curls. I serve the 9th District of Kansas City. Thank you for allowing me to present Senate Bill 742. Mr. Chairman, this is a good Samaritan or a good neighbor bill, is what I'm calling it. Senate Bill 742 will allow a person who is not the owner of an abandoned or suspected abandoned property who is acting in good faith to enter onto the premises of a property or to enter the property to secure the property, remove trash, mow the grounds, and remove paint or graffiti for those persons to be immune from claims of civil and criminal trespassing and any other liability, except in cases where the act constitutes gross negligence or willful or intentional misconduct. Mr. Chairman, this bill is really seeking to address some of the issues we're having in Kansas City with vacant and abandoned property. Some of the neighborhood organizations want to maintain or spruce up some of the abandoned property. A large portion of those, 60% of the vacant and abandoned property we have in Kansas City happen to be owned by banks or out-of-town institutions. And what the neighborhood folks are wanting is to come up, be able to board up some of those houses, be able to mow them on, to be able to clean up trash without being charged with trespassing on those specific properties. I think that's about it in a nutshell. I'd be happy to answer any questions.
Any questions for the sponsor?
Mr. Chairman.
Senator?
Did we hear this last year?
I think you did.
Okay, so that this was, you were asked for this, I'm sure, by those who own the properties and don't feel like they have access. Is that how this bill?
Well, a lot of the neighborhood and community organizations, and I do have folks here who are willing to testify on what the specific issue is in Kansas City. And here's the deal. As I said, we have a bunch of vacant and abandoned properties. For those neighbors who are wanting for these abandoned properties that the folks have not responded, especially to citations from the city, overgrown property, they are fearful of being charged with trespassing just by coming to either mow the lawn that has not been cared for or to pick up trash on those properties. And we're just wanting to relieve them of liability of being charged with trespassing in those cases.
And these are the parties that are.
This would only be abandoned property though.
Right, and the parties that are being released are the ones who have some vested in. I mean, they have some
Right, it's their
standing
block.
on the property.
Absolutely. We have a number of neighborhoods and a number of blocks in Kansas City where, you keep your property up and your neighbor across the street does, and the neighbor down the street, but then you have 2 vacant houses that are horrendous. The windows are broken out, but there's trash around the perimeter. There's the grass may be 3 feet tall, and so folks in the neighborhood are wanting to come clean up some of those properties, of course, trying to maintain their property value as well.
It doesn't have to be someone who has any ownership. It can't just be a next door neighbor who says, I'm tired of this grass not being cut. Nobody lives here, I'm gonna go cut the grass.
Absolutely, yes.
Without this, they could be charged, somebody could suddenly show up and
be charged with trespassing. Right.
Okay, thank you.
think last year we passed a provision that allowed neighbors to employ, I think it was a pro bono attorney, to actually bring a class action or class action, a civil lawsuit. But it was not in all parts of the state. I don't know if that would be something that your constituents would be interested in as well. I know we've had some discussions down in our part of the state about perhaps expanding that provision.
Okay, I certainly will talk with the folks that are not testifying next.
Any other questions for the sponsor? Okay, those in favor, please come forward.
Good afternoon, everyone. My name is Peter Hoffman. I'm a staff attorney with Legal Aid Western Missouri. We represent nonprofit neighborhood groups in urban Kansas City areas on problem property issues, including filing nuisance actions, abandoned housing act actions, to try to encourage owners to fix up those vacant properties. Just want to give you an overview of the scope of the problem that the city of Kansas City is facing. Last year, the city of Kansas City the mayor commissioned an environmental task force to study the vacancy problem in the city. That study reported that there were 16,000 vacant properties in the city of Kansas City, Missouri, some of those with structures, some of those without. Every year, that costs the city about $11 million in nuisance abatement costs. Over last summer alone, there were 10,000 open property violation cases. So it's a significant problem, the dumping, the trash, the tires, and it just has overwhelmed the city. Neighborhood groups, neighborhood leaders would like to be able to have some flexibility to be able to enter on to certain properties, which are pretty narrowly prescribed in this bill, that are abandoned or have been vacated or walkaways from foreclosure, to enter that property to make very limited sorts of improvements and be protected from trespass. So, as the senator said, things like cutting the grass, boarding up or securing the property, maintaining the lawn, painting over graffiti, improvements of that nature. It wouldn't be a blanket immunity from negligence or other sort of more egregious acts on the property.
Are you aware, do you think there might be some interest in the legal community in your area for representing folks that we're talking about on a pro bono basis with regard to civil action against some of these absentee folks? I mean, I bring that up just because I'm thinking about this this bill that we passed. I think it was last year, maybe the year before. I've heard recently that it's working very well in a limited area, but it was limited to pro bono work.
Right.
I was curious if there'd be any interest in your knowledge.
There definitely is. I'm the project director for Legal Aid's Adopt a Neighborhood project, where we've actually brought in 5 large pro bono law firms to partner with 5 urban core neighborhoods to bring those types of nuisance actions. It's, as I mentioned, though, it's a significant problem. Our volunteer attorney project is pretty robust, but we'd be happy to take on more pro bono advocates for our neighborhoods for sure. People would be willing to do that, but each property is different, and the facts of each property have to be looked at carefully. So I would love to say that there was some blanket solution to this problem, but unfortunately, we kind of got to look at them on a case-by-case basis.
Well, and you mentioned the common denominator being that, you know, local government doesn't have the resources to police, or I should say to enforce some of the things that we're talking about. Senator Schmidt.
Thank you, Mr. Chairman. Yeah, so this is an interesting question because you have some communities that are overzealous when it comes to this, let's just say that. And then you have some communities, primarily with bigger cities, St. Louis and Kansas City, that don't have the resources to sort of keep up. 2 years ago, Senator Nasheed had a bill that came through my committee that, and there were some pretty limited criteria by which a community group could be formed to then essentially prosecute an action that the city councilor's office would normally prosecute, and take it through the court system and then have a decree which essentially would be in compliance. The only concern I have here, you know, and I've worked a lot in the area of real estate law. The idea of self-help is not favored under the law. I mean, to the extent that even a landlord who has a, you know, prior to the order being final and knows that the tenant is gone, can't just go in and start getting the place ready. And there's a reason for that. It leads to conflict and situations that aren't good. So I really appreciate what you're trying to do here, because I do think this is a significant issue. I just wonder if we have something already established. And it sounds like you may be more organized than the folks who are in St. Louis about lawyers being willing to help and partnering with communities to sort of go the legal route on their behalf.
And I can speak to that. Okay. That's statute is 82-1025 to 82-1030. It's actually been on the books for a long time, but just last year it was amended, and it added a lot of those qualifiers for neighborhood groups to be able to have standing to bring that action. At one point, our office would bring that action on just about every case we would bring, which was about 60 to 80.
Did that apply to Kansas City though? I thought it was, okay, we must have added Kansas City. I thought it was one for the cities.
Right, and so those changes have actually made that bill less workable, make that statute less workable than it was in the past, because the burden to bring a case is so onerous. What this would do would empower neighbors to just enter on the property and make limited improvement, and it's really carved out. Just, they're not going to be able to go into that property and rehab it under this statute. They're not going to be able to go in and gut it. It's really just secure the property and make these limited types of improvements that would probably be too onerous to bring a legal action on. For somebody to get permission to enter to cut the grass.
Yeah, I'm looking at the section. In section 3, it basically says, with respect to actions taken pursuant to the section, the structure or building which has been continuously unoccupied by persons legally entitled to possess for at least 6 months. That's a very complicated legal scenario in some ways. I mean, I don't know if it's a renter. I'm not sure how a neighbor will be able to ascertain who's lawfully possessing the property. I mean, the concern is not the goal, you know what I'm saying? But someone says, oh, the Missouri legislature passed a bill for me to go cut my neighbor's grass if I think it's too high. And then we have confrontations, or there's a pit bull that's in it. I mean, these are the kinds of things that reason why self-help is disfavored in general.
Right, and these protections would not apply to those properties. It wouldn't apply to occupied properties. It's only the vacant properties. And I think if that were to come up in a court action,
I'm sorry, I don't mean to interrupt.
No, go ahead.
Who determines that it's unoccupied though?
Well, I think the neighbors are probably in the best position to know how long the property's been vacant.
Yeah, somebody could, I don't know, maybe somebody's not there for a month. Maybe there's a death in Arizona and they're going, you know what I mean? Like,
right, and then in those circumstances, this defense wouldn't prevent them from prosecuting that trespass as a trespass. It doesn't meet the requirements of vacancy under this, so that person who would be a trespasser then wouldn't be able to use this as a defense, because they wouldn't be able to show that that property has been vacant for more than 6 months, or tax delinquent, or the other elements that are kind of outlined in this book.
Well, look, I appreciate what you're trying to do, and I'd like to work with you as a sponsor, because I think getting away from cities viewing a property as a way to sort of siphon revenue is a different kind of challenge that we're confronting in other parts of the state. And but I do think that in general, we're probably limited to the two big metro areas on this. I could be wrong. Springfield may have this challenge. Columbia may have this challenge. I don't know.
In this bill, it is just right now limited to Kansas City. It could be expanded if it turns out that this is a bill that works.
Okay, thanks.
Okay, we're going to try to move along because we do have I've been informed there's a committee meeting in this room at 3. Any final questions for this witness? Thank you very much. Anyone else to testify in support? Please come forward. Anyone to testify in opposition? Please come forward.
Good afternoon, Jim Durham on behalf of the Missouri Land Title Association. I've already talked with the senator, and I think she's very amenable to just adding a little provision in here that says whoever would do this work would not be entitled to a certain mechanics lien against the property.
Okay.
We'll make those adjustments before.
All right, thank you. Then I withdraw all my opposition.
All right, thank you. Next,
Okay, I have a question. That was
Senator Ongo.
Oh, yeah. Yeah, Jim, in general, though, unless absent a contract for that work, or some, there wouldn't be grounds for mechanics lien anyway. You just want to clarify.
Our primary concern is the guy who comes along and says, you know, I fixed the stairs there, I painted some of it, and I've been cutting grass for the past 6 months.
Right.
I'm entitled to get some compensation.
Yeah.
I'm gonna do this.
You just want to clarify this,
That, yeah, that mechanics lien is.
Under our present law, that person wouldn't have a mechanics lien in this scenario, I wanted to think.
The
But
question is whether the bill kind of authorizes, because like if the city would come in and say, we're going to fix this.
Yeah.
They could actually assert a mechanics lien.
the city can right now.
Okay. It's, and especially when you get closer to like a neighborhood association.
Got it. Okay. Thank you. Yeah.
Well, the rest of the issues, yeah.
Yeah, that's good. That's good. Yeah, yeah.
Thank you, Mr. Chairman. Hey, Jim, the other issue too that occurred to me, which would be easily addressed, but you know, the common law aspect of adverse possession.
Right.
If I'm the neighbor and I'm cutting the grass for 10 years, that's my front yard now.
And actually, we would have no problem with that whatsoever. 10 years.
He's making a list of properties.
Yeah, I know, I gotta think about it. Where's Glendale?
I think there's someone in your general neighborhood who's already kind of done.
I walk the four corners of my property regularly.
All right. Thank you, Jim. Anyone else to testify in opposition? Okay, that'll close the hearing on Senate Bill 742. We'll move to 743.
Oh my gosh, okay, last one, try to be quick. For the record, Senator Kiki Curls of the 9th District of Kansas City, and I am presenting Senate Bill 743. Mr. Chairman, Senate Bill 743 basically requires landlords to separate security deposits received from their general bank accounts. The bill prohibits commingling of security deposits with personal funds of the landlord. It also provides that a landlord who wrongfully withholds a security deposit is liable up to twice the amount of the deposit of damages. The problem we're trying to address are the landlords who go bankrupt, or those who experience foreclosure and have spent the security deposits of the tenants. Those who have not rightfully returned the deposits, and currently in the statute there's no protection for tenants for which this has happened. Those folks who wrongfully retain the deposit should be liable up to twice the amount of the deposit. Several other states allow 2 to 3 times the deposits plus attorney's fees to be recovered by the tenant in that instance. I'll say that currently about 40% of persons who lose homes to foreclosure are tenants, and those tenants often lose their security deposits. I will say that part of this is, of course, to address an issue we have in Kansas City, but also it was brought a few years ago from students in Columbia and MU, where there was several students that lost security deposits. They had cleaned up the place, and they never received those deposits. They had talked to an attorney about litigation, and there basically is not anything really in statute that attempts to help the tenant house. So with that, I'll be happy to answer any questions, but if you have any questions, there is an attorney here that's an expert witness that could probably more adequately answer those.
Why don't we just open it up to those that are here to testify in support first?
Chairman, members of the committee, I'm Michael Duffy. I'm an attorney in Kansas City with Legal Aid of Western Missouri. I've been asked by the senator to come and describe some of the reasons for this bill and what the bill says. It's intended to address, as the senator mentioned, 2 features of the tenant security deposit, which need addressing under current law. One has to do with the situation where, through some change in circumstance, the landlord has died, or his property has been foreclosed upon, or gone into receivership or bankruptcy, or for whatever reason, the landlord no longer has control over the security deposit, tenant security deposit, and it just becomes lost. That's most common in the foreclosure situation. The landlord owns the property and the tenant is in the property. The tenant has a security deposit. The landlord has usually disappeared at that point, and oftentimes the security deposit is lost. Not through any malign intent of the landlord, but just because of the change in their circumstances. The second situation has to do with landlords who, for whatever nefarious reasons, do wrongly withhold the security deposit. And I'll take that second circumstance first. It's probably the minority circumstance. Current law provides that if a landlord wrongly withholds, and by wrongly I mean that it's not a matter of damages to the unit, this is a wrongly withheld security deposit. Current law says that the tenant is entitled to go to small claims court if it comes to that point and recover up to twice the amount of the wrongly withheld tenant's deposit, security deposit. The proposed bill here would slightly change that language to say instead of up to twice the amount, it would just say twice the amount. Most judges now do award twice the amount, but we have had circumstances in my practice where some judges have said, well, landlord didn't return the deposit, you have to return the deposit instead of twice the amount. In other words, there's really no penalty on the part of the landlord for wrongly withholding the security deposit. Now, for a judge who makes that kind of award, there's really no reason for the landlord not to roll the dice and say, well, I'm just going to sit on that deposit and let the tenant sue me, and the worst that's going to happen to me is I'll have to give back what I would have had to give back anyhow. So the intent of the statute, I think, has always been clear that there would be some penalty on a wrongly withheld security deposit. And the bill here would clarify that that penalty is twice the amount of the security deposit, period, no more, no less. Numerous states around the country have similar language. Model ABA-approved landlord-tenant statute requires the same kind of absolute penalty. It's both intended to protect the landlord and the tenant. Protects the tenant in that there is a minimum penalty. Protects the landlord in that there's no open-ended liability. It caps the liability at twice the amount of the security deposit.
Yeah. I have to open it up for questions at this point. Any questions of the witness? Senator.
Thank you. You know, I do think part two of the new bill addresses a very real problem. Certainly the vast number of landlords behave honestly and forthrightly, but even with my limited experience with renting properties, it seems some landlords, part of their business model is that they're going to keep the security deposits, and that's despicable. Actually, 20 years ago, when my wife and I were married, she no longer needed her apartment, and she gave the landlord notice and so on, and he tried to withhold the security deposit. She's an interior designer, though, and she had before and after pictures and all that, but still I would have had to go to court. Of course, I have a law degree, so I could write him a nasty letter that talked about punitive damages and things, and I got the security deposit back, but most tenants don't have that. So, no, I think at least this aspect of your bill, I do like. Thank you.
Any other questions? Thank you very much for your testimony.
If I could have 30 seconds, Mr. Chairman.
We are really short on time. I'm sorry I have to limit everybody to 3 minutes. If you have anything you want to distribute, though, if you'll get that to us, we'll get that to the committee. Next in favor, very quickly. Anyone else in favor? Anyone in opposition? In favor, go ahead. If some of the other witnesses want to have a seat at the table for the next testimony, that would be fine. Proceed.
Good afternoon, Mr. Chairman and Senators. I want to thank you all for your time and consideration for this bill. My name is Nate Theus. I am a representative with ASUM, the Associated Students of the University of Missouri System. And on behalf of the 77,000 students in the University of Missouri System across all 4 of our campuses, I want to speak and testify in favor of this legislation. We believe that there are a lot of cases that are arising concerning these lawsuits and the practices that we've already seen, and it is affecting students very negatively. Most students right now do not have the legal knowledge or resources available to them to effectively combat these poor practices, these bad business practices. And this legislation would be a much needed fix by reducing the amount of lawsuits that entangles both landlords and the tenants. It would also reduce the amount of pressure put on the Attorney General's office, which is currently has jurisdiction to deal with all of these arising lawsuits. It is part of our legislative platform, which has been secured by 4 different leaders from across all 4 of our campuses to promote this legislation. And we hope that you all consider it with the utmost importance. Thank you very much for your time. I'm open to any questions you have.
Any questions quickly for the witness? Thank you very much. Anyone else in favor? Anyone? Go ahead.
Mr. Chairman, members of the committee, and Power Missouri would like to go on record in support of the bill. We don't have anything new to add, but I welcome any questions here.
Thank you very much. Anyone else in favor? Anyone in opposition? Just a reminder for everyone to fill out a witness form.
Mr. Chairman, members of the committee, Sam Licklider, former Missouri Realtors, I will tell you right now that I am very in opposition simply to preserve the record. Mr. Duffy and the senator and I have had I think, a very productive conversation. Our concern is that the real estate licensees already are required to keep their funds in an escrow account, and the initial bill does not require an escrow account or a trust account. It simply says may, which is of absolutely no help in the event of a judgment or a bankruptcy. What we would like is an exception or an exemption, if you will, for real estate licensees who are all, I mean, there are at least 3 places in the statute that require them to do this, and that it be in a trust account, some sort of a custodial account, so the money is available. Because if I just put it in another account in my name and I get a judgment, it's gone and not back to the tenant. And I know you all have had a bad situation in your college leasing, because everybody has. I would prefer that.
Any questions for the witness?
If we can get this language worked together, Mr. Duffy has agreed to do that. I think the senator has agreed as well. That I think we're doing with my exception.
Okay. Thanks very much. Anyone else?
Good afternoon, Craig Overfelt with the Missouri Bankers Association. We're in a little bit different position, but similar to the previous witness. We have some language. We've talked to the senator and Mike Duffy, and we just want to make sure the bank is not the trustee. We've got a fix for it, but the landlord would open an account as a trustee and not the bank.
Okay. Thanks very much.
Thank you.
Anyone else in opposition? Okay, that'll close the hearing on Senate Bill 743. Thank you, Senator. We'll now move to Senate Bill 893, Senator Munson. A reminder, if folks will have their witness forms filled out and ready to go ahead and have a seat at the table if you're in favor. We're going to move very quickly. Brevity will be rewarded.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Brian Munson of the 18th District. This is a bill actually presented before your committee last year. It actually would encourage public response or personal responsibility. What it deals with is if there are warning labels and directions and instructions, and you have misused the product in contrast to what is required on the label or in the warning, in the manual, whatever, that if any product is used and is, well, this act provides that when the trier of fact determines in a product liability case that the harm was caused solely as a result of the plaintiff's fault, then the defendant shall not be liable for the harm caused solely as a result of that fault. The definition of the term fault is modified in this bill to include the use of the product in a manner inconsistent with the specification or standard application of the product. The use of the product in a manner contrary to an instruction or warning, as I said, and the use of the product in a manner determined to be improper by a federal or state agency. And last year I brought up the case of the gas can, which was actually sued 42 times, 42 lawsuits. They had to fight off 62.
42 of those lawsuits were people pouring gasoline on a fire and the gas can exploded, when it explicitly had a label that said against that. Also, a case of a beer bottle, a lady being hit with a beer bottle, and Anheuser-Busch and the distribution company was sued because the bottle caused harm when she got hit. You know, a lot of these products, if you look at any owners or operators manual, the very first thing you see inside are the warnings. They're there. There's a lot of warnings on products. And a lot of times you look at some of these warnings, did somebody really do that? Yes. Somebody evidently did that, and was sued, so they had to put it in the warning. But like I say, mine encourages personal responsibility.
Okay.
Glad to answer any questions.
Any questions? Seeing none, those in favor? Anyone in favor? Very quickly. If you're going to speak in favor, go ahead and have a seat at the table.
Richard Bromley on behalf of the Missouri Insurance Coalition, American Insurance Association, State Farm Insurance Companies, etc. We just like to own record being supported. I think it's fairly obvious, so I know we've heard this before. I'd be happy to try to answer any questions if I can.
Okay. See any? Thank you very much for your testimony. Anyone else in support? Anyone in opposition?
There was, I know at least one, maybe two people dropped some in support, dropped by my office.
Go ahead and have a seat.
We'll get it to you.
Go ahead and have a seat. I can't listen to witnesses, but we'll make sure the committee gets the information.
Missouri retailers also want to be hand up in support.
I can't list them as a witness, but go ahead and leave it at the table.
Okay.
They're here to answer questions. Anyone else in opposition?
Good afternoon. My name is Jay Benson. I'm a lawyer from Kirksville, Missouri, and I'm here on behalf of the Missouri Association of Trial Attorneys. I had a whole bunch to say. We take the whole 3 minutes, but I know you're in a hurry, Senator. So let me just say that that our products liability law in Missouri has been in place since 1965, when our Supreme Court adopted what's called Restatement Second of Torts, Section 402A. It's the law across the land. It was the law back in the 70s when the Ford Pinto case that we've all heard about had occurred. Ford Motor Company knew that they had a defective gasoline system, and they chose not to fix it. They chose not to fix it when it was apparent that 11 cents per vehicle would fix it. Instead, they did a cost-benefit analysis to determine that it would be cheaper to settle lawsuits than to pay for the fix. And it's this very law that we have in place in Missouri today that held Ford responsible for that. And if we go away, if we were to adopt Senate Bill 893, we would give companies like Ford the opportunity to produce these dangerous products. Our law is currently governed by the prior version of this bill in 537-765. It's codified in an MAI verdict director. It's the verdict director that the jury is given when they are deciding the case. And it addresses the issues of misuse. For a jury to find for a plaintiff in a lawsuit against the manufacturer of a defective product, the findings are that the defendant sold the product in the course of the defendant's business, that the product was then in a defective condition, unreasonably dangerous when put to a reasonably anticipated use. Third, that the product was used in a manner reasonably anticipated. And fourth, that the plaintiff was damaged as a direct result of such defective condition. Those are the uses that are referenced in the old version of this in subsection 4(1) and 2. Those provide for the jury to consider the fault of the plaintiff by any kind of misuse of the property, or the product rather. But what this bill does, senators, is it gives the product manufacturer an opportunity to avoid liability by the additional language in subparagraphs 3, 4, and 5. 3 relating to specifications or standards. A product manufacturer can develop a standard. A trade group consisting of these industries can develop a standard that says whatever it says, and all of a sudden the product manufacturer is off the hook. The same way with the warnings. This law would destroy decades of case law relating to warnings, and it would effectively give the ability for a manufacturer to literally let the fox guard the chicken house. Because the warnings, if you have a warnings issue like exists here, it doesn't matter that the product is defectively designed or made. They're off the hook because of the warning. So,
Go to questions. I'm sorry to cut you off.
Okay.
Very quickly, Senator Sifton.
Yeah, so just to summarize, the new sub 3, sub 4, and sub 5 that are in the bill are not in the restatement, correct?
That's correct.
Thank you.
Senator, real quick question.
Very quick.
Senator, I agree. I mean, because I always read warnings, because they're really funny sometimes, actually, translations from other languages and things. But, you buy a circular saw, and it will say, do not place circular saw on your head. And you think, did somebody really do that? But also, I've bought products, and, like you buy a circular saw because you're going to cut wood with it, and the instructions will say, not designed for cutting wood. And you say, wait a minute, you can't say that. This is what you just sold me, this product. So that's the flip side of the issue, too, on the warnings is, trying to get away from all liability by selling you a product for intended purpose, but then putting in the warnings, it's not intended for that purpose. So I just raise that because I see that all the time.
Thank you. Thank you very much.
Real quick question, Phil.
Go ahead.
So you would say, you read the MAI jury instruction, you would say that, well, if you have a gas can, it's reasonably anticipatable, if that's a word, that someone might use it for the fire, so they should have made the safety gizmo that's now on gas cans.
And then they're off the hook because they've given you that warning. In the design, in the safety design, there's 3 rules. First, you design against the hazard. Second, you guard against the hazard. Third, if you can't do either one of those 2 things, you warn against the hazard. Under this law, if you warn against the hazard, you don't have to worry about the design or the guarding of it because you're off the hook on the warning. And that's a big reason why this is a bad bill.
Got it. Thank you.
Thank you.
Anyone else in opposition? That'll close the hearing on Senate Bill 893. Thank you, Senator. We will now very quickly move to Senator Wallingford's 2 bills. It looks like we may have to recess this hearing. 618 will be first. I apologize, we have a very heavy workload today.
Thank you, Mr. Chairman. With this legislation, first of all, I'm State Senator Wayne Wallingford, representing District 27 for use Bill 618. This proposed legislation would prohibit the detention of youth tried as adults in adult jails before they turn 17 or are sentenced to the adult program. Youth would instead be placed in juvenile facilities. Additionally, the legislation would form a task force and develop the process of transitioning youth now detained in adult jails into juvenile facilities. The prohibition would come into place on January 1st, 2017. All youth whose cases are certified for process in the adult court after August 20, 2016 would be placed in juvenile facilities from the start. And Mr. Chairman, I had some brilliant opening introductory remarks designed to persuade and convince you why this is so important, but I know we have several people working in the industry who want to tell how this will affect them, so if we could go to witnesses.
Let's hear from them. Those in favor. Was this introduced last year, Senator, or she's got
Mr. Chairman, that's my question. Is this the same exact same language as last year?
I don't know if it's exact, but very close.
Good afternoon again. My name is Natalie Hull. I am a public defender, but I'm here on behalf of MACL with the Juvenile Justice Committee that we have, and we are in support of this bill. The immediate thought that I have is the case that I won when I represented a certified juvenile who was 16 years old and was in the jail. At the end of his trial, he was found not guilty. A week later, he was back in jail. That's not because of anything that happened except what happened in jail. He made friends. And the education that he was not being given by the state because he was at the jail, he was getting from other people in the jail. And so what he learned there was how to be a criminal, not how to be a productive member of society.
Any questions? Seeing none. Next in favor.
Greetings, I'm Reverend Dr. Dietrich Wise Baker. I'm the clergy co-chair for Metropolitan Congregations United, and I've been a juvenile detention chaplain for 11 years. I'm probably one of the few people in the room that are in a detention center every single day. We are in favor of this bill, Metropolitan Congregation United, because one, these children are not guilty of a crime, yet they are removed from the juvenile detention centers where they are supported with educational and mental health resources and placed in an environment with adults that subsequently sometimes expose them to abuse, and they are vulnerable. And so we would support that juveniles stay with juveniles.
Okay, let's do favor.
If you would please allow me to read my notes, I've actually never spoken in public about my son.
If you would mind to summarize those, and if you'll provide us a copy of your written testimony,
Okay,
I'll make sure
fine.
that everyone on the committee gets that.
Okay. My
Feel
son
free
was
to
taken into custody at the age of 15 years old, and he was transferred to a juvenile facility in Camden, Missouri. 3 months later, he was certified as an adult and immediately placed in jail. He was not segregated from adults. While he was there, he was harassed by the guards and the other inmates. He was beaten, he was stolen from, and ultimately he was sexually assaulted. I managed to get my son home on house arrest for 2 years, and during that time, he did obtain his GED. While he was in Camden 10, he did finish up his sophomore year. They did provide for schooling in the juvenile facility, which is a major plus for that environment. What we ran into with the GED is he was not technically old enough to be able to do that, so we had to get a special accommodation for that. However, you cannot take the GED without it not being associated with the public school system, and he couldn't do that due to charges. We did find a community college that would allow him to do that. He did get his GED. The week of October 2014, we had the trial, and they came back with a guilty verdict. Immediately placed him back in jail, where again he was not segregated from adults, and again he was beaten until he was transferred to a prison in Farmington. Now he was 5 hours away from home, and he was placed in a juvenile part of that prison. But when he turned 18, he could no longer be with the juveniles. He could also no longer be with the adults because his level of security was higher than that prison allowed for. So for the second time, he was placed in solitary confinement. The first time being the first jail when I called and the attorney called demanding that protection be put in place for him, and their response to that was to put my son in solitary confinement for 2 weeks rather than deal with the fact that he was being sexually assaulted. During that 2 weeks, my son started having suicidal thoughts. Today, he is in prison in Cameron, Missouri, where he will finish out a 30-year sentence. While he is in there, he is locked up in a room with another inmate in a room that's no larger than a walk-in closet. He spends 23 hours a day in that cell watching television. Because they placed him in protective custody, he has no schooling, he has no job, and he has no access to any type of religious activity. So my son's brain isn't developing. There's nothing that's challenging him there. And in his own words, as we heard previously, his education right now is the other prisoners. He has seen people raped. He has seen people forced into gangs. And it's all I can do every day to keep my son from going down that path. I too have a child that had never been in trouble. He had never even been in trouble with the school system, much less anything juvenile. I thank you for hearing me, and I'll be glad to leave
Thank you
letter
for
with
your courage to come and speak to us today. Would you mind to state your name for the record? We've got to keep track of the witnesses here.
My name is Joy Knopf, and I live in Kansas City, Missouri.
Joy, thank you. All right, any?
One more, Your Honor.
Okay. We've been working very diligently to accommodate the other committee. They're going to meet next door, so we have alleviated some of the pressure on ourselves, and we'll be able to get to the other bills. So the governmental accountability, if you stepped into the room and you're expecting to meet with the governmental accountability committee, they're actually going to meet next door in SCR2. Any questions for any of these witnesses? Thank you all again very much for being here. Next in phase.
How you doing? My name is Sylvester Faulkner, and I was certified at 15. As an adult, I spent a month and a half in juvenile detention was sent to jail. My experience in jail, it was a hard experience because like in juvenile detention, they provide you with counseling, school, and different resources to help you mature as a kid, become a, in jail, it's like you don't get the resources, you just start. You have to worry about the COs, the staff that work there, the inmates. I have been threatened by COs that work there, inmates, and it was just a whole different experience. So I think keeping juveniles in detention centers, juvenile detention centers is more healthy because, like I said, they have their counselors there that you can talk to them, but like you can't talk to nobody else. They can go to school and learn and get an education right there.
Any questions for this witness? Thank you very much. Testimony. Anyone else to testify in support?
Mr. Chairman, members of the committee, Alex Eater from the Union ACLU, Missouri, legal and record this board.
Thank you.
Rachel Greenhouse with Empire, Missouri. Pretty much everything has been said, but we do support this bill for a couple of reasons: safety, education opportunities that are allowed in juvenile system or in juvenile facilities compared to adult facilities.
Okay, thank you. Next in favor.
I'm Rita Lynn, arguing with Missouri Capital Conference on bill on residents with this bill with our church meetings.
Thank you. Anyone else?
Mr. Chairman, members of the committee, my name is Marcia Hayes. Of course, I'm the Executive Director of the Missouri Juvenile Justice Association. Some of you may recall that last year we appeared in front of this committee, actually in opposition to a similar bill that Senator Wallingford had filed that required youth who have been certified as adults to be held in juvenile detention facilities. At that time, while we completely supported the concept and continue to do so, we expressed several concerns about holding these youth in our juvenile detention facilities. We have 17 juvenile detention facilities that serve the 114 counties plus the city of St. Louis. There are significant issues around holding these youth in juvenile detention facilities that we believe have to do with safety due to the nature of the offenses committed by some of these youth. There's some significant financial impact to the counties for holding these certified youth in the juvenile detention facilities. Since that time, we've been working with Senator Wallingford as well as other proponents to try to come up with some language that we can all agree to. And it's our understanding, we've talked with Senator Wallingford, and we understand that there likely will be a committee substitute that has some language in it that sets up a work group rather than a task force that will actually look at all of the issues around removing these youth from jails and placing them in some type of alternative facility. We believe that having the opportunity to have the right people on a task force or work group that would actually look at all these fundamental issues around this issue and look at all the possible solutions and come back to the General Assembly next year with some recommendations on where these issues should be placed. So with that said, with our understanding that the possible committee substitute and that change in language, we would be able to support the bill.
Okay. Any questions? Senator Romine.
Yeah, I think I remember your testimony from last year, and that's the concern. Although we do in principle agree that we don't like to see youth held with adults, we are talking about 17-year-olds who are accused of a crime bad enough that they're being certified as adults. I don't know, I've been reading the bill here. They correct me if I'm wrong. But anyway, so my county's expressed concerns about that, about whether those 17-year-olds are going to be a bad influence on the let's say 14-year-olds who are in the juvenile detention facility. Of course, there's always a lot of concerns about cost, but I think we'll work with the bill sponsor on on St. Charles County's concerns. I think they estimate it would increase our population pretty substantially and It's a pretty large cost, but we'll visit with the sponsor.
And so Your Honor, it actually would be youth under 17 that have been certified as adults. And then those youth currently, after they're certified, they're held in the county jails, which would be
Okay. So
specifically
it'd be 16
under
or
17.
16 or under. Okay, got it.
Yes.
Okay.
And
Yeah,
I think that the same concerns continue to be for your juvenile officer in St. Charles County. But we're willing to come to the table and be part of that work to really come up with a good solution, because we also agree they do not belong in county jails.
Okay, thank you.
Senator, go ahead.
We have been working very closely with the Juvenile Justice Association, and just when I arrived in the hearing room, I was handed the Senate committee substitute. Have not had time to review it. I'll let Juvenile Justice Association review it, but I do know the working group is definitely a part of it.
Okay. All right. Thank you very much. Next in favor. Anyone else is welcome to come on up and have a seat at the table, so you're ready to go.
And to the chair, members of the committee, thank you for the opportunity to share my support for this. I'm Beverly Newman. I'm the Chief Juvenile Officer of the 17th Judicial Circuit, and I'm also the current president of the Missouri Juvenile Justice Association. I too, like the young lady sitting next to me, spend every day in juvenile detention, except when I'm here under these circumstances. So I'm very well versed on the issues, and I believe that the amendment that has been proposed and the discussions that we've had are in the interest of children that may be in that circumstance being certified and not yet convicted, but also to address the safety risks and concerns that may otherwise exist.
Thank you very much. In favor, please.
Hi, I'm Tracy McLeod. I'm the president of Families and Friends Organized for Juvenile Justice. And Senator Wallingford and I have been working on juvenile justice reform for several years. And I, of course, support this bill. And I just wanted to remind you that we're talking about 20 kids or less. So it's not raising the age of 17, we're just talking about the certified kids that are in both county jails.
Okay. Thank you. Next in favor.
Hello, my name is Rod Jennings. I'm from the University City. I just wanted to state on record I'm strongly support this bill.
Okay. Thank you, sir. Any questions? Anyone else to testify in support?
Michael Barrett, State Public Defender, just want to go on record in support of the bill.
Okay. Anyone else in support? Anyone in opposition? Anyone in opposition? Okay, that'll close the hearing on Senate Bill 618. We'll now move to Senate Bill 684.
Thank you, Mr. Chairman. Again, I'm State Senator Wayne Wallingford, representing the 27th District, and I bring before you Senate Bill 684. Under current law, the court must consider dual jurisdiction of both the criminal and juvenile codes when sentencing an offender who is under the age of 17 and a half and has been certified as an adult. This act specifies the court must order an evaluation by the Division of Youth Services to determine whether dual jurisdiction is appropriate for the offender.
Any questions for the senator? Okay. Anyone to testify in support? Senate Bill 684. Go ahead.
Hi, again, I'm Tracy McLeod with Families and Friends Organized to Reform Juvenile Justice. Jonathan's Law was named after my son, and when we testified back in 2013, this committee voted unanimously to support it, and then it voted unanimously in the Senate and then in the House, and this is just a tweak to please give all certified youth a chance at the evaluation for dual jurisdiction.
Any questions? Thank you. Next in favor.
Natalie Hall with the Macro Juvenile Justice Committee. We're on record in support.
Okay. Anyone else?
Rachel Greathouse from Parole, Missouri, voting on record.
Okay.
Leland Hartford, Missouri, Catholic Conference, so on record in support.
Anyone else?
Jenny Schrappen, I represent Metropolitan Congregations United St. Louis. I support the bill.
Okay.
Mark Baker, back on record, Metropolitan Congregation United. This is Ash Wednesday, and just like we all expect a possibility of transformation, so do our juveniles. And this bill gives
children a possibility for transformation, and we should make sure they have it. Thank you.
Again, my name is Joynoff from Kansas City, Missouri. When we were going through this process, no one in our family had ever been through any type of criminal process, so it was our issue. We were not even aware of what dual jurisdiction was until having met Teresa McClard. It was never anything that was offered to my son. It was never anything that was discussed. As a matter of fact, the prosecuting attorney informed the judge that he had to certify my son because there was no facility he could be placed in Missouri given the severity of his charges.
Okay. Any questions? Okay. Just as a reminder, if you have that other testimony, we'll make sure that. Anyone else to testify in support or go on record in support? Go ahead.
My name is Jackson. I'm actually a graduate of the dual jurisdiction program, and I just want to, I guess, make everybody aware of how important it is to have a juvenile be evaluated by the dual jurisdiction program, because I mean you can just tell from the evaluation that it's hope there. Like, and it's not a lot of places to look for hope in jail. It's not a lot of places to look for hope in jail at all. And so during that evaluation, you can really tell that they're there to help you. And in jail, there's not a lot of people there to help you. So I guess what my job is to really just bring the awareness to the people of the dual jurisdiction program, because not a lot of people are aware of the program. So not a lot of people, they don't really know what they're facing when it comes to the dual jurisdiction program and exactly what it does for you in the justice system. So that's pretty much my job.
Thank you very much. Any questions for this one? Thank you for being here. Anyone else to testify or go on record in support?
Michael Barrett, State Public Defender, one of the records.
Thank you. Anyone else? Anyone in opposition? Okay, that'll close the hearing on Senate Bill 684. So much paper. We will now move to, and thank you again, Senator, for waiting, Senate Bill 729, Senator Sibley. Let everybody go ahead. I appreciate it.
My apologies. Oh, no, I understand. That said, I will be striking this quickly to head up to education, where I have another bill being heard at 3 o'clock. Mr. Chairman, members of the committee, Scott Sifton, the 1st Senate District, here to present Senate Bill 729. This is the DNA sampling bill that this committee heard last year. Under Missouri law currently, whenever an individual is arrested on certain felony charges, but not any felony charge, on certain felony charges, including murder, rape, and some other sex crimes, we take a DNA sample to see if the DNA taken matches any other profiles in CODIS, the federal database. A number of states will sample DNA in all felony cases, and by doing so, end up solving a lot more unsolved crimes, exonerating innocent individuals, and basically just catching more bad guys. 5 states have gone so far as to actually take samples in misdemeanor cases. My bill doesn't go that far, but for what it's worth, in New York, where they take samples in misdemeanor cases, 1,786 petty larceny samples matched 78 homicides, 343 sexual assaults, 235 robberies, and 764 burglaries. Mr. Chairman, there are an awful lot of crimes that are not getting solved and prosecuted in this state because we are not taking DNA samples in all felony arrest instances in our state. To do that, to expand, to include all felonies, would cost money. We would have to process more kits, but I think it's well worth it. A number of states would report that they have experienced significant savings in terms of crime prevention and lower investigation costs and closing files as a result of more broader sampling practices. I will say that the Public Defender's Office has reached out and indicated that one of their concerns is they want to be able to access samples for purposes of exonerating the innocent. And what I would say is that that's something I'm more than happy to talk about. I would want to hear law enforcement's perspective on that as well. But the reality is we can be putting more people who are guilty of crimes, serious crimes, behind bars in our state than we are. And this is a great way to do it. Happy to answer any questions.
Questions? I guess it's just the two of us now. Other than there's Senator Everett down here.
It's a quorum.
Those in favor? Go ahead, I'm sorry.
Matt Selby, Sun County Prosecutor, on behalf of the Missouri Association of Prosecuting Attorneys. Just want to go on record in support of the bill. Not only does it just match to take the crime that happened, but it also puts it into the database so that if a crime has occurred in the future, and so it becomes a very powerful tool for investigating and catching serial rapists, murderers, and things like that. So I don't really have anything else to add.
Any questions? Thank you very much. Anyone else in favor? Anyone in opposition?
Again, Sarah Rossi, Director of Advocacy and Policy with ACLU of Missouri. This is actually a rare instance when I am on the same side of a decision as Justice Scalia. We think this is a very blatant Fourth Amendment violation. Just because you're arrested for something doesn't mean you're guilty. There should be a process for obtaining a warrant and actually doing a search of a person's body. This is actually not just, touching a fingerprint or taking a picture. They're actually putting a swab into your mouth. And even though it's a minimal invasion, it's still invasion. I understand the desire to solve cold cases and arrest people and charge them for crimes like sexual assault and things like that. I actually used to be the legal director at a sexual assault organization. I care very much about it. But as we've already said, those kind of crimes, sexual assault, murder, other violent felonies, those DNA samples are already collected at arrest for those kinds of crimes. So if it's a serial perpetrator, they're already going to be in the system. It's just an invasion of privacy issue for us. I think it violates the Fourth Amendment. I think the Supreme Court got it wrong. I don't often like saying that, but in this case, I think they did. So we're opposed. I understand the intention, but I think it goes too far and violates our Fourth Amendment rights. I also am generally opposed to databases of any sort operated by the federal government.
Okay. Any questions, Senator Smith?
Thank you, Mr. Chairman. And this would go for either one of you. So we heard this last year, right?
Yes.
So what the Supreme Court has ruled on this issue on arrest versus conviction?
Maryland v. King, 2013, Scalia was outvoted, basically holds that swabbing a DNA sample is really not a whole lot different than taking somebody's fingerprints when you book them. It's for purposes of identifying the arrestee.
But in order for us to have it in our database, we have to authorize it in the statute.
Right, correct.
And I think it should be clear that the Supreme Court decision was that you can do it, not that you have to do it, or that you should do it. It was permissive.
Okay. Any other questions? Thanks very much. Anyone else in opposition? Okay, so now that will close the hearing on Senate Bill 729. Thank you, Jason. And